Right, good morning, everybody. Let's get started. My name is Charlotte Hadfield. I am the head of 3PB's Education Group, and I am joined this morning by Alex Leonhardt, a member of the Education Group. Both of us are also members of 3PB's Employment Group, and we do a lot of incidental discrimination and personal injury work within those sectors. This morning, we are presenting the second of the 3PB Education Group's three-part webinar series focusing on issues arising in higher education. And this morning, Alex and I are going to be talking to you about damages in civil education claims. So there will be a presentation by me and Alex, followed by some questions and answers. Alex and I are going to cover issues that we find commonly arising in civil education claims, particularly in relation to calculating damages. So today we are going to cover Consumer Rights Act issues. We're going to do a quick overview of schedules of loss. We're going to talk about loss of chance, loss of earnings, injury to feeling, and personal injury, and then we will take questions. And I am going to hand over now to Alex to talk about the Consumer Rights Act.
Thank you, Charlotte. I thought it would be useful to talk about the Consumer Rights Act as part of this talk, firstly, and most obviously because it is relevant to claims for damages, or at least for monetary compensation in some higher education cases. But also, I expect most people on the call will be aware of the fact that the very large group claim against UCL was settled fairly recently, and the same company, as I understand it, who brought that claim is inviting claimants who want to bring claims against other universities. And I've not seen the pleadings in the UCL case. If anybody has a copy of them, please send them to me. I'd be interested to see them. But I'd be surprised if the Consumer Rights Act didn't play a role in those pleadings. Before I came to the bar, I worked in higher education policy, when the Consumer Rights Act was making its way through Parliament, and part of my job was to explain to universities that indeed students were consumers, which came as an enormous shock to a lot of people, including university vice chancellors. That in itself came as a shock to me, because the Consumer Rights Act didn't actually establish that or make it true. So it's something that both claimant side lawyers and certainly universities and those that represent them need to be aware of, because whether university vice chancellors like it or not, students are consumers and are entitled to Consumer Rights Act remedies. Um, Having said that, I feel sometimes that the Consumer Rights Act doesn't interact particularly neatly with higher education, because as far as consumer contracts go, higher education is probably about as complicated as it gets in terms of services that are provided. And maybe we'll see one kind of outcome of that as I talk. So what are the remedies available under the Consumer Rights Act, and when? By when, I mean in what circumstances. It's just that would have gone off the edge of the slide. So we are talking here about where there is a breach, or where a contract is not performed in accordance with sections 49 or 50. Now, section 49 is the term of is the section of the Consumer Rights Act that incorporates into every consumer contract the implied term that it'll be performed with reasonable care and skill. And section 50 that is referred to there in subsection 2 is the section of the Act that effectively incorporates as terms of contracts things that are said by the service provider that influence decision to enter into the contract or to make decisions within it. So in effect, things that would normally be relevant to misrepresentation. So in a higher education context, what that would include is details about modules, for example, and how they're delivered. Very often, obviously, it's subject to any qualifications that are published alongside the information given. And then the remedies available there at section 54.3. Well, these are the most interesting and pertinent ones. Firstly, the rights to repeat performance, and then secondly, the rights to a price reduction. Now, obviously, a repeat performance is not technically damages, but since we're here, I thought we may as well talk about it. Repeat performance is a right available to a consumer where there is a relevant breach of the contract that requires, in essence, the service provider to repeat the service. Now, I mentioned earlier higher education often fits kind of quite ill at ease into this context, because one imagines that the typical services that would be covered in a consumer contract are done relatively swiftly and are relatively self-contained, whereas the service in a higher education contract is a degree, or at least, at the very least, a module of a degree, depending upon how the contract is framed. And so you can see very easily how the provision of the Act that looks like it might be quite reasonable to impose upon a service provider may become quite impractical or difficult to perform when it comes to higher education. The relevant section, which I'm afraid I failed to include on the slides, I'm afraid I'll update that for the slides that are actually sent out, makes clear that it is subject to the fact that it's actually reasonably practical for the service provider to provide the repeat performance. Of course, these are rights that are normally expected, frankly, to be claimed by a consumer without going to a court. The anticipation is that it'll be claimed by the consumer pre-action, if you like. And when you look at what powers the court has to actually enforce repeat performance, this is section 58.2, which is now actually on the slides, that where a consumer makes an application to the court may make an order requiring specific performance. Now, you will note the word may, and so this is clearly not an automatic right that somebody has to go to a court to require specific performance. And just to make that clearer, sections 58.3 and 58.4 make clear that the court can give an alternative remedy under the Act if the effect of the provisions that are relied upon by the consumer, so in this case, the repeat performance provisions, have the effect that exercise of another right is appropriate. That's fairly vague, I'm afraid, and part of the difficulty with the Consumer Rights Act is because the claims involved are often quite low in value, there's very little authority. It seldom gets to the High Court or Court of Appeal. But one can read from this that the court, in effect, has a degree of discretion to make an order that appears sensible to it. And so, in summary, the repeat performance is in theory open to students or ex-students as a remedy where a relevant breach of the Consumer Rights Act is applied. And on the surface level, it looks like it provides students or all consumers with perhaps an easier route to requiring specific performance, because normally that is a remedy that the courts are very unwilling to order. However, in the context of higher education, in my view, it might be quite difficult to persuade a court that it is the appropriate course of action, particularly by the time you get to a final hearing or a trial in any matter, which may be some time after the year in question or the actual module in question. And in any case, by the time you get to a trial, it could be the case that the claimant or the consumer is no longer particularly interested in going back to that university to complete that course. It is nonetheless something that would be certainly worth exploring from a claimant perspective in early correspondence with any higher education institution where a Consumer Rights Act breach is relevant. The second remedy is phrased as price reduction. Now, the reason this is interesting is because it differs, of course, from the normal remedy under contractual rights, which would look at loss that flows from the breach, whereas a price reduction is much more like the remedy available in rescission. It's about what has been paid out by the consumer rather than the damage caused by the breach. And we can see again, it's phrased in fairly broad terms. The right to a price reduction is the right to require the trader to reduce the price by an appropriate amount, which can be more than the contractual amount if more than was charged. It can certainly be the full amount. The consumer's only actually entitled to this remedy if they've either repeat performance has been refused by the service provider or where it wouldn't be practical anyway. The question, therefore, is obviously, well, how much would be appropriate? Now, as I said, the provisions are framed fairly broadly, and a court is likely to and inevitably must take a fairly broad brush approach. Now, firstly, it should probably be recognised that it will be a very rare case where a student gets no benefit from the contract or even from a particular module that was badly affected. And that will be reflected in the amount of any price reduction that would be sensible to agree from the perspective of a higher education institution or would be awarded by a court. In terms of how one may go about calculating the appropriate amount to claim or to offer from the higher education institution perspective in settlement, one approach might be to calculate on the basis of the credits of the module or modules that were affected, and then reflect on the extent to which they were affected. It has a little bit in common, this approach, with the approach taken in disrepair cases in property claims. If anybody's at all familiar with that area of law, where one looks at the number of rooms affected and the extent to which they're affected. Having said that, my instinct, at least, is that the courts are likely to have a degree of sympathy with students who make the argument that the whole was affected by spoiling of the part, that what they were after what they contracted for was delivery of the course as a whole. And so even if only one module was affected, it did in some way at least affect the whole course that they were seeking to pursue. And perhaps if one reflects on an example of, for example, a graduation ceremony that wasn't provided, the institution may seek to argue that that really is a very small part of the service provided, but from the perspective of the consumer, it might be a very important part of what they bargained for, and a court might have some sympathy with that. So the sensible approach is probably to look at the credits of the module affected and to do a proportionate assessment based on the tuition fees. But the court, in my view, is likely to err on the side of slightly greater than that amount rather than slightly less. So in summary, price reduction claims, they're most likely to be claimed, whether explicitly or implicitly, as a remedy in low value claims. That is why I've dealt with this topic first, because it's quite different and will normally be involved in quite different sorts of claims than what we're going on to discuss. By their nature, there will often be small claims, because if only 1 year of a course was affected, then assuming somebody is paying domestic student fees, then the amount is capped at 1 year's tuition fees. Price reductions don't actually require any actual financial losses. So they are, in that sense, much easier to bring from the claimant's perspective, and may often be a remedy sought by litigants in person bringing claims. And the court will take a broad brush approach in considering the effect of any breach of the Consumer Rights Act. And so, as practitioners on either side, so should you, in seeking to settle the claim. Given their very low value claims, obviously it would normally be probably quite sensible to settle them unless there are wider considerations about floodgates and encouraging new claims. So that is the summary I wanted to give on Consumer Rights Act claims. As I said, they will often be involved in quite a different set of claims from those that we're going on to discuss. And the first topic on those more complex claims is probably one of the first things you should be thinking about when you are bringing a claim from the claimant's side, and that is what is in the schedule of loss and how to put it. And I'm going to hand over to Charlotte to discuss that.
Right, so we wanted to give an overview about schedules of loss. In my experience, this can sometimes be treated as a bit of an afterthought or a thing that you need to kind of patch together as best you can at the end of drafting your particulars and at a point where there's quite a lot of pressure to serve. So my first headline on this is your schedule of loss is a really important document. Ideally, it is not an afterthought, but it is something that you're working on from the moment that you get instructed. And obviously, a lot of the reason why I get some cases where, the schedule of loss is a bit of an afterthought is because the client has instructed relatively late, and all of this is having to be thought about at a sort of later stage than is ideal. But in an ideal world, you're thinking about your losses at the earliest possible stage in the claim. And the reason for that is that the amount that you are claiming, well, I suppose I should start by saying, claimants may want lots of different remedies, but one of the common features is nearly always going to be some sort of financial recompense. So they are normally going to be looking for damages as part of that claim. And the schedule of loss at its most simplest form is where you set out what you want. So the schedule of loss is the answer to the question, what are you looking for when you bring this claim? A schedule of loss that is drafted early and drafted well tells the other side really important information and frames your case in the way that you want to if you're acting for the claimant. So it sends a message to the other side, which could be, if you engage with us now, this can all go away relatively easily and painlessly. It could be, this is going to cost you an awful lot of money and an awful lot of hassle. It's very technical and it is worth discussing now with a view to ADR. Or it could be we are in completely different places and we all need to batten down the hatches because it's going to be a long haul. But the schedule of loss is going to say some very important things about your case. And one of the things that I like my schedules of loss to say is, we've really thought about this. Here is the evidence to back up what we're asking for. It's an important tool for managing expectations. So, for example, very frequently, particularly in higher education cases, you might get somebody who has been, I don't know, withdrawn from something like a medical degree or another professional degree, and they come to you and they say, I now can never be, I don't know, an accountant, a lawyer, a doctor, whatever it is. And I estimate that I have lost well over £1 million over the course of the lifetime of that career that I could have had but won't. And that's what I want to get back. So it's important to start thinking about it early so that you can manage client expectations about what they can get, and also so that we don't fall into the trap of over pleading the claim, because remember that the value of your claim is directly related to the issue fee that you pay. And what you don't want to do is issue a claim in the sum of £1 million and pay a £10,000 issue fee if the reality is that your claim is somewhere in the 20 to £30,000 bracket. So that's really important. The other thing that the schedule of loss will do will inform thinking about without prejudice discussions. You might want to serve a schedule of loss early with a Part 36 offer, something like that. So it's a really, really important document. And here on this slide, we've just got an excerpt from the case of Wright against Satellite Information Services Limited, where Mr. Justice Yip talked about the importance of the schedule of loss. And I've just realised that I actually don't know what Justice Yip's gender is, and it's quite possible that somebody's going to put in the chat box that I've got it wrong, in which case I apologise to everybody. But in any event, what was said was this, that the importance of the schedule of loss is frequently overlooked, which was my starting point. It should be the document that draws together the presentation of the claim. It ought to be presented in an accessible and easy to follow format. The fact that the schedule of loss is required to be supported by a statement of truth highlights the need for it to be readily understandable by the claimant. It also sets out the claim for the defendant and for the trial judge who will come to the case afresh and ought to be able to follow the case from the schedule. This means that it should not simply be a series of calculations. It needs to be supported by sufficient narrative to explain the case being presented by the claimant. So, in addition to everything else that I've said, this is part of the pleadings, it's part of the advocacy, it's part of the narrative that you are putting forward at the very beginning. I knew it. Somebody has pointed out that she is female. I apologise to everybody. Thank you very much for flagging that to me. Okay, so I've just set out here an excerpt from the pre-action protocol for personal injury claims, because a lot of the higher education cases that I do can include some element of personal injury. So it's not uncommon to find somebody who's been withdrawn from their course, who has suffered a psychiatric injury, perhaps, something like an adjustment disorder, or perhaps something, a bit more serious, up to and including something like complex PTSD. So the other thing is that you always need to say to yourself which pre-action protocols apply in my case. And certainly for personal injury claims, there is a requirement if the defendant admits liability, and I would argue it's wise, even if the defendant doesn't admit liability, to send a schedule of loss as soon as reasonably practicable. And you can see that the pre-action protocol does anticipate that these can be provisional documents, they can be subject to change, and the schedule should say so. And you can see the key bit really is towards the end of this paragraph, where it says the claimant should keep the defendant informed as to the rate at which his financial loss is progressing throughout the entire protocol period. When you're drafting your schedule of loss, remember what I said about it being part of the advocacy. So this is part of your opportunity to set out the stall for your client's case. And I will pause here and say that often where there is a schedule of loss, there will follow a counter schedule of loss. And so defendants will also want to be thinking, if they put in a counter schedule of loss, how they want to set out their case. And what I am saying applies as much to those counter schedules as it does to the original schedule. So it's a good idea to start your schedule of loss with a head note, and to explicitly say in that head note that this is a document that is provisional and may be subject to change, maybe amended or added to as the case goes on. A little bit of a chronology is a good idea. Any multipliers that you're using, particularly if it's a personal injury case and you've got specific multipliers to think about, is very helpful. An introduction or preamble that sets the scene, and then to explain each head of loss, just to give a very short explanation as to broadly how you have reached that figure. So a schedule of loss could just be a list of columns with the head of claim on the left and the figure on the right, but I find it's much more useful to just put a little bit of narrative in broadly about how you calculated it or what you're taking into account. So, for example, if you're saying injury to feelings and you're putting yourself in a particular vento band, and we will talk about that later on, you might want to say here what vento band you're putting yourself in and why you have chosen to put that, what the features of the case are that justify a vento in that category. And then complex calculations. So, for example, if you're doing something fairly heavy duty and you're getting out Ogden or something like that, you can put that working in an appendix to the schedule of loss so that the document itself is easy to follow. So I think what I really wanted to do at this stage was just to showcase the importance of a really clear schedule of loss that is carefully thought about and that you have been working on from the beginning, because apart from anything else, it can just be really, really hard. So what often happens is you have this kind of frantic back and forth about the schedule of loss at a point where perhaps you only have a few days to serve. And remember that your schedule of loss needs to be served along with your particulars of claim. So even if you've issued protectively and you've got your 4 months to serve your claim form and your particulars of claim, you need to have your schedule of loss appended to those particulars, along with any medical evidence that you're relying on, and so on and so forth. It will depend on the kind of case that you're bringing. But it's so much more helpful to be able to think about it in advance, because the worst thing you could have in that situation would be suddenly realizing either that you have overinflated the claim or that you have undervalued the claim, and then you have the sort of general anxiety that can sometimes persist about, well, I've underpaid the issue fee. Are we at risk of strikeout? Is somebody going to say that we've abused the process of the court? And on that note, abuse of process of the court, that slightly apocalyptic note, I will hand over to Alex to talk about loss of chance.
Thank you. I was going to talk about the concept of loss of chance because it so often is a feature in higher education claims, particularly the higher value, more complex ones. That is because the loss or damage incurred by a student as a result of breach of contract or negligence or discrimination will often be uncertain, because the student may not have graduated in any event, even if there hadn't been any unlawful actions by the institution. And even if they had, they may not have achieved their stated career goals in any event. So what is a feature certainly of the maybe more widely publicized cases in this area is a claim by a former student that if they'd only completed their study, they would have got a training contract at Clifford Chance, for example. And I think everybody on this call knows that even a first-class degree doesn't guarantee you everything you might want in any career you might seek to have. The first point that they may not graduate in any event is, I think, an important one to bear in mind, because what is often also a feature of this case is that they do often involve students who may already have been struggling, or certainly from the higher education institution's point of view, that argument will be made. And it's rarely the case, frankly, that there was a one-off act that completely changed the direction of somebody's study and their success in their study. So these things need to be taken into account. So the question is, how does the court take it into account, and how does it differ from any other decision the court might have to make? The fundamental difference is that when a court is assessing somebody as having a loss of chance, that is, a loss of chance to succeed in their course, or a loss of chance to have a particular career or to succeed in it, they use a probabilistic percentage approach and not the normal balance of probabilities approach. To expand on that a little bit, there will be all sorts of decisions and findings a court has to make that are, in a sense, uncertain. A judge or a court can never know for certain, for example, somebody's motive in a discrimination claim. And if, as everybody here will know, if there's a 51% chance of something happening, in most cases, the court treats it as if it did happen. And just to draw out the difference further, if a claim requires two independent events to have happened, and a court considers that both of them had a 51% chance of happening, then the court considers that both of those events happened, and therefore the claim succeeds, even though, if one knows probabilities, it's actually near 25%. So it is a very different approach. So when does the court use a loss of chance probabilistic approach, and when does it use a balance of probabilities approach? The difference is where there is a fact that something happened or didn't happen, and it's just the court is not can't be sure about it, then the balance of probabilities approach is the correct approach. But where we are talking, for example, about what career a person may have had if they had graduated, there is no fact of the matter. It's a hypothetical situation, and that fundamentally is the difference. There's a little bit more to it than that. It's quite a complex area. I just wanted to flag it as something that needs to be borne in mind in these cases. On the next slide, which I will skip over, but will be sent to you, there are two key authorities that are probably worth a quick read and a quick read around if you're interested in this area. But loss of chance generally is the appropriate approach to take where one is looking at the decisions that third parties might have made. So, for example, would Clifford Chance have given this person a training contract? And they're not a party to the claim, they're not a party to the contract. And so the court should take a loss of chance approach to that question based on the evidence that it has. However, where one is looking at what the claimant or defendant in a case would have done, uh, it's not the appropriate approach to take. The actions of a claimant in a hypothetical situation are determined on the balance of probabilities rather than loss of chance. And the actions of the defendant are determined in accordance with the contractual obligations, but it's assumed they will perform their contractual obligations at minimum cost to themselves. So it is a slightly technical, complex area, and the key or the most important point to remember is that where one is looking at loss of earnings in cases in this area, almost certainly there will be the decisions of a third party involved, which are uncertain. There is no fact of the matter because it's a hypothetical, and therefore loss of chance is the appropriate approach in that case. I said there were some key authorities. These are really the key authorities in this area. So if it's something you want to look at in more detail, these are the ones I'd recommend you look at. All of that really was a bit of a precursor to the next topic because it's most relevant to that topic, which is loss of earnings. And I'm going to hand back over to Charlotte to talk about that in more general terms.
Thanks, Alex. So, at any given point for loss of earnings, we are looking both forward and backward. And typically, the question that arises is partly in terms of looking backward, you're looking at causation. What can you say you have in fact lost, or your client has in fact lost? That was caused by whatever the unlawful conduct is that is alleged against the defendant. And in a sense, that's an easier exercise because you're sort of looking at concrete things that have already happened and saying to yourself, did this happen because of that? Or can it be argued that they happened for some other reason, or that they would have happened anyway for some other reason, which means that we effectively have not suffered a loss because whatever happened would have happened anyway. So if we go to the next slide, one potential source of both past and future loss of earnings is employment. And the reason that it comes up sometimes in education cases is because there are times when somebody is employed because they are working towards a particular qualification, for example, and then if for any reason they are not able to complete that qualification or they fail the examinations for the qualification, it may lead to a consequential loss of employment. Now, to the extent to which the higher education institution is responsible for that will vary massively because there may be situations, for example, where people are on, I don't know, clinical rotations on a paid basis, for example, depending on what you're studying or what you're qualifying for, or other professional rotations or placements. And the loss, being withdrawn from that course will result also in the loss of that vocational placement. So there's that. And there may be other situations where you are employed on a particular basis, you're pursuing, I don't know, a diploma or some sort of perhaps more discrete, smaller type of qualification, and then you are not able to continue in your employment or to get a particular benefit from it because you've been withdrawn. And so the purpose of this slide really is just to keep you broadly aware of the kind of things that you could be looking at when you're thinking about loss of earnings or loss of employment benefits or a reduction in them. So if the claimant is employed, then you obviously think about what they're earning, and any reductions in earnings or loss of earnings that they've experienced. But you would also look at things like car benefits, phone, subsistence, clubs, Bupa, or other health insurance, share schemes. Some people are housed. whilst they're carrying out work on a particular basis. So that's a thing to think about as well. Don't worry too much about the subrogated claim point in the second bullet point. And then for self-employment, it's profit that you claim, not income. Silent partners seems unlikely to arise in this sphere, but I put it in just in case. And then if there's a limited company involved, then you're looking at salary, dividends, and retained net profits. So just a few things to bear in mind in relation to loss of earnings. So it doesn't necessarily bar you from claiming compensation for income undeclared for tax, but it's important to have a look at that authority. Earning and drawing benefits will be, and earnings from an unlawful source may be. So that's just looking at the kind of earnings you can and cannot be compensated for if you lose them. And then going to slide 24, just a little on loss of pension. So when it comes to loss of pension, particularly if you're looking at a career loss claim, which we'll come to in a minute, when it comes to loss of pension, particularly over a long period of time, you may well want to get actuarial evidence about that. So that may be expert evidence that you want to get rather than trying to do the calculations yourself as a lawyer. We've always got to be mindful of our own expertise. And this is one of the areas where it might be acceptable to say to the other side, well, look, here's my schedule of loss. We are in the middle of getting, or we are in the process of instructing experts to deal with the pension loss over the period that we're claiming for. So we have a few little pointers here so that you can find your way through expert evidence, but it is important to bear in mind that one question in your mind should always be, is this something that we can claim for properly at this stage without getting expert evidence in relation to it? Okay, so now we come to career loss. And typically in a case like this, it would be something like the claimant is studying for studying on an accredited degree, so maybe something like social work, accountancy, a law degree, a medical degree, a nursing degree. They're withdrawn from the course, and depending on the circumstances, they may be saying that they have been delayed in their access to the labour market because they've got to go and find a provider, or perhaps they haven't been withdrawn from the course, but they failed a component of it, and they're going to have to retake a year, or they're being told they should take a year out, and they say that this is unlawful, or that the circumstances that led to that were unlawful, even if the decision itself was reasonable. So sometimes they may be saying, I've been delayed in my access to my nursing career or my medical career, and that will impact me across the course of my career. And accordingly, I think I have lost a very large amount of money that will be very difficult for me to recover. And again, that is a situation where you might be looking at employment market evidence from an expert and actuarial evidence to calculate exactly what that loss might be. And secondly, they might be saying, I now just can't get in. So you see this quite commonly where people have been withdrawn from degrees either because, so in some areas, because they failed. So, for example, it can be very difficult indeed to complete your medical degree at one school. If you have previously failed it at another school, it can be very, very difficult just to find an institution that will let you try to repeat that year. Or they might be saying the circumstances in which I have been withdrawn make it impossible for me to pick it up. So, for example, if they're saying that they have unlawfully or wrongfully been accused of something like dishonesty or some sort of very serious disciplinary offence in their institution, such as physical or sexual abuse or something along those lines, they might be saying it is functionally impossible for me to enter that career now. And obviously, these are potentially very high value claims, depending on whether it's a delay case or just a bar to the profession case, and depending on what earnings could have been across a lifetime in that profession. So, the questions that we always have to ask ourselves are firstly, what is the claimant doing now? So, sometimes a claimant will say, well, I've gone off and I've decided to do something completely different. And the question that you will have in mind, particularly if there's a breach of contract issue in the case, will be, well, what has the claimant done? And this might be something you want to put in your schedule of loss. So if you're claiming career loss, you might want to say in your schedule of loss, the claimant made X, Y, approached X, Y, and Z medical schools following his withdrawal from the course and has been told by all of them that they will not take him because of A, B, and C. And so that will be your evidence for your career loss. If the claimant sort of shrugged their shoulders and said, oh, well, I'm just going to go off and do something else, if it's something, say, particularly unrelated, the claimant was withdrawn from their social work course and now they've gone off and they're doing, I don't know, a philosophy degree, or, they've kind of decided to remove themselves completely from that sphere and start afresh. That may have implications, obviously, in terms of whether they've mitigated their loss or whether they can show they've mitigated their loss. The other thing that you might want to think about is how was the claimant doing generally? Because the claimant may be saying, I was withdrawn from my course. This comes back to what Alex was saying about a loss of chance. The claimant says, I was withdrawn from my course, and if I hadn't been withdrawn, I would have passed. It is worth looking at their marks because in some cases you will be able to say very clearly, there's no possibility that they would have done because look how they were doing. In other cases, you might say, maybe, maybe not. But I think you can always, it's always open to the defendant to say to the court, you can't be absolutely sure that anyone will pass, even if somebody's doing really, really well in years 1 to 4 of a 5 year degree. You don't know what might happen in year 5. They might get sick of it. They might decide they want to do something else. Year 5 might just prove to be the year where they realise it's not for them. Year 5 might be the bit they can't do. So it's worth when you're a claimant thinking realistically, am I claiming 100% of this at this point? And if I am in the schedule of loss, do I have a maybe a more realistic bottom line or top line in the back of my head about what my percentage chance might actually be? And these cases are potentially very, very factually, evidentially, and legally complex. And that's one of the reasons why, if you're valuing a career loss, it's really good, if possible, not to be doing it 2 days before you've got to serve your claim. And then just to raise again, in complex and high value cases, you may expect expert evidence. Certainly, as practitioners, we should be thinking about expert evidence and whether we need it. And, you can have a broad brush approach. So I have seen cases where it hasn't necessarily been possible to prove a specific, you might say, well, okay, I can't say that I would have become a doctor, but I can say I would have graduated, and I can say that I would have worked in this sort of, I would have worked in England, and here is the average, so there are figures that you can identify, what's the average graduate salary for somebody in this area at this time. And it won't necessarily be what you get at the end of it, but it is a starting point for your schedule of loss. And then obviously there are more straightforward and low value cases where you can just sort of say, well, actually the claimant has managed to get into the labour market. They have entered the profession. They haven't been delayed by very much. And, that's something we can calculate relatively easily and relatively concretely. Okay, so I will hand over now to talk to Alex about injury to feeling.
Thank you, Charlotte. Very often these cases will be claims that involve multiple different allegations of unlawfulness, and very often there will be a breach of contract claim pleaded alongside, in particular, disability discrimination, failure to make reasonable adjustments, or perhaps a Section 15 claim on the basis that a withdrawal from a course was a breach of Section 15. I'm going to deal with this section perhaps in a little bit less detail than we have previous, just because I'm conscious of the time and that we should have at least some time for questions. But also, I suspect that this area may be slightly more familiar territory for many of the people on the call. Now, firstly, obviously, injury to feeling awards are only recoverable for claims of discrimination in this field, and they will almost always flow from a finding of discrimination. They are at least intended to be, and at least in theory, compensatory rather than punitive, and are intended to compensate for feelings of upset, humiliation, violation, not feelings of injustice, indignation, or anger. Drawing the distinction there is not always as easy as it might be. First, as I think many of you will be familiar with, the bento bands provide the framework from which injury to feeling awards are made, named after the case at the top of that slide. They are updated in accordance with inflation, and they're also periodically updated, I think every year, by presidential guidance for employment tribunal cases. Even though clearly these are not employment tribunal cases or indeed employment cases, that updated presidential guidance is probably a useful resource so that you don't have to do inflation calculations yourself. And I can't imagine a court would have too much trouble accepting those figures, although, of course, I could be wrong about that. Those are the bento bands. Again, I expect most people are fairly familiar with them. I'm not going to dwell too long, except to say that where we're talking about withdrawal from a course, and where somebody was studying full time, my suspicion is you're often talking somewhere at the lower end of the middle band, assuming that the conduct was not particularly egregious. And the reason I say that, as Charlotte has said earlier, both of us are employment practitioners alongside being education practitioners, and the kind of lower end of the middle band is normally your starting point for loss of employment. And it seems to me that where somebody is studying full time, it's a very similar analogous situation. Um, just as somebody's identity is often tied up with their employment, somebody who's a full-time student often will identify as being a student, and that might be one of the first things they say about themselves. And so it seems to me that it seems a very comparable sort of situation. Of course, as I said, they're meant to be compensatory, not punitive. So you really should look at the particular effect upon the claimant, and not the seriousness of the wrongdoing. Although, in my experience, courts and tribunals do use the wrongdoing itself as something of a proxy for the upset caused. The exception from that and the departure from that is where you have very clear evidence, in particular supported by perhaps medical evidence from a psychiatrist or somebody similar, that shows that somebody simply did experience a much greater degree of upset than might be normal or might be typical. This slide covers the point I've just made. So I want to reiterate that the formal approach of the law is they are compensatory, not punitive. I think you just have to take that with a pinch of salt when you're coming up with your figures and seeking to justify them. These are the sorts of factors that you should consider when deciding perhaps where in a vento band a particular award should sit. Firstly, are we talking about overt discrimination here, harassment claims, for example, or are we talking about unconscious bias, or a kind of fairly straightforward failure to make reasonable adjustments claim where perhaps the decision on whether an adjustment was reasonable was a finely balanced one? Was the discrimination public in its nature or its effect? Does it involve ridicule of claimant? It doesn't involve ridiculous claimants very often. For example, were they criticised in front of classmates? For example, is it a one-off incident or is it a kind of campaign of discrimination? Something that courts are advised to do in determining awards is to look at what awards are granted for personal injury claims, and to make a common sense comparison, so that, in essence, discrimination claims, I think, are not overvalued by comparison to what somebody would get for a broken leg or a broken arm, for example. And I'm also advised to consider the value of the award in everyday life. So perhaps a fraction of average earnings, for example, might be a useful benchmark. It's important to scrutinise, and the court should scrutinise both the possibility that a claimant is perhaps exaggerating their upset, to put it slightly cynically, but also they may be overly stoical. You do get cases where people are, for various reasons, not able or willing to express the upset that they felt. And you should be alive to those situations just as much as you're alive to the situation of a claimant that is all too ready to explain the upset that they've experienced. And now, even more briefly, I'm going to talk about personal injury, general damages, as it applies in these cases. These would almost always, one suspects, be psychiatric injury, often tied to an act of discrimination. That's certainly the most common factual scenario here, where somebody had a psychiatric injury that was worsened as a result of a failure to make reasonable adjustments, for example. Now, firstly, and this is a point that ties in with what Charlotte said earlier, questions of general damages, pain, suffering, and loss of amenity need to be included in the schedule of loss, and you should include in that details of the injury and the treatment that was received, the prognosis, and of course, for where you're claiming personal injury in the civil courts, of course, you should be looking at the relevant pre-action protocol and complying with it, which includes the need for expert evidence. You should include in the schedule of loss the proposed bracket for the under the Judicial College guidelines, and adjust them in line with inflation. There's a kind of example of a calculation there. And you can, if you want, compare similar cases in order to justify the figure you've reached. I'm going to skip over, because we don't have much time, special damages in personal injury cases. General damages, I've covered these points. A couple of tricky issues emerge in personal injury cases, because, as I say, these are typically psychiatric injuries we're talking about here. Firstly, where there is a worsening of an injury, but it is not new. And secondly, where there is more than one cause of a psychiatric injury. Some of those causes may not be unlawful. And so, in theory, at least, a defendant wouldn't be liable for them. Where there is a worsening, but not a new psychiatric injury, a defendant is only liable for the worsening and not the whole. Now, it's important to distinguish between a pre-existing condition that got worse and a mere vulnerability to an injury. So if a claimant is merely vulnerable to injury and then suffers it, then the eggshell principles apply and the defendant is liable for the whole. That is a different situation from where somebody is already suffering from an injury and it is worsened. The distinction between those situations and, of course, the extent to which somebody's condition is worsened is something that would need to be addressed in expert evidence. And this is the even trickier issue, in my view, is where there's more than one cause. And it doesn't, the obvious situation where this can arise is where a claimant pleads, even on their own case, that, say, 10 acts of discrimination have occurred or 10 breaches, and all of them have caused personal injury, and then they only succeed on 2 of them. Well, one might think even on their own case, therefore, only a part of the injury they suffered has in fact been caused by any unlawful conduct. But there were also situations where external events would have affected the claimant during, after, or before any discriminatory conduct and contributed to the injury. The principle here, and again, it's quite technical, so I've given an overview and the name of the kind of leading authority on it, which is Barbara and Somerset County Council. That was a stress personal injury case arising from an employment context, but the principles should apply to other contexts as well. The question is whether the injury suffered is, and I quote, truly divisible in terms of cause and effect, rather than where there is simply a kind of an admixture of different causes. What that means in practice, if somebody can do a webinar on what that means in practice, I'd be grateful to attend it. It's quite a complex area. I think this is probably also an area where the expert evidence would be very helpful in determining whether, for example, these are 2 discrete causes that have contributed to a whole, and they are divisible in their effect, or whether this is just all part of a worsening that you can't actually sensibly separate out into different cause and effect. And the final point I wanted to address is where there's overlap between injury to feeling and personal injury. So you can, or a claimant can claim personal injury as part of a discrimination claim, and very often, for example, where there is a worsening of a psychiatric injury as a result of discrimination, then the same effect upon the claimant can be fairly described as both injury to feeling and personal injury. So it's actually quite common for there to be an overlap. Now, the key point is that, of course, both sides should recognise and the court should recognise that there is a potential overlap and there shouldn't be double recovery. So the best approach, in my view, is to value both of them separately, as if they were entirely separate, and then to adjust the amount to recognise the fact that there is overlap. In some cases, there will be almost complete overlap, and really the personal injury is simply an aspect of the injury to feeling award. In some cases, there will be perhaps very little overlap. So, for example, if there were multiple forms of discrimination and only some of them, for example, relevant to a disability, you might make the argument that a person's feelings of humiliation and upset existed quite separately from the worsening of, for example, anxiety or depression that they suffered. So you need to take a sensible approach as to the extent to which there is an overlap and make sure you recognise it. So that covers the topics I was going to cover on injury to feeling and personal injury. I just want to, on behalf of Charlotte and I, give our thanks to 2 members of 3PP's personal injury group, Hamish Dunlop and Mark Sullivan, who kindly gave us some drafts of some slides in relation to the relevant sections. And with that, I'm afraid we've only got a few minutes for questions and answers.
So the first question that we've had is, if a student wishes to claim for an exacerbation of a pre-existing mental health condition, which they claim has been directly caused by the provider's breaches of contract, would it be recommended to attempt to value at Vento or to instruct an expert such as a psychiatrist to provide an independent report to value under the JC guidelines? Would the cost of said expert report be recoverable? So I think technically, I think if they were bringing a claim for an exacerbation of a pre-existing mental health condition, they would need really to be bringing that under either a claim for personal injury. So you could have a breach of contract claim alongside, but in order to be compensated for a personal injury, they would need to be bringing either a personal injury claim, or if it was a discrimination claim, then they could ask for it to be taken into account in calculating the Vento award. So there can often be overlaps, as Alex was saying, between Vento and personal injury awards. So to some extent, it will depend on how they've brought the claim. If they've just said you breached the contract, and also, by the way, it has exacerbated my mental health condition, then I think, you'd be sort of saying, well, you're going to need to explain how you can get anything back for that at all. If they've brought a personal injury claim, it depends what they're asking for, I think. I probably, if it's a recognizable condition that I have a diagnosis for, where the value is likely to be greater than the cost of instructing an expert, I think I probably would want an expert to value it. What do you think, Alex?
I think it depends upon the extent of the worsening of personal injury that's being alleged. There are cases where, in my view, it's probably more sensible to just view it as part of the
Mm,
injury to feeling award. One can, where if you're claiming it under the Equality Act, then I think it would be fair. And all you're saying is, and my anxiety and depression got slightly worse as a
yeah,
result. That would be a fairly
that's
modest
Vento.
award. Then it's probably best to deal with under Vento. You can still, of course, introduce evidence, whether CPR compliant evidence or not, to justify that.
Yeah,
But where you are looking at a very significant worsening, and really that is the bulk of your claim, I think a court would bulk at
yeah,
simply lumping that in with an injury to feeling award. So probably in those circumstances, I would suggest probably expert evidence. But I think it depends upon the relative value of that personal injury element within
yeah.
the whole claim.
I agree. I mean, so for example, like Alex was saying, if you're sort of a bit anxious, sorry, this sounds terribly trivializing. If you have a kind of general condition of anxiety and that is exacerbated, then that should be recognized, but it's probably more cost effective and straightforward to throw it into the Vento mix. If, on the other hand, you're somebody who lives with complex PTSD and you were functioning, you were working, and you were generally managing, and then something as a result of this unlawful conduct, you are unable to work, you are hospitalized, perhaps you are no longer able to be in the employment that you were in, or or to continue on your course. That's the kind of thing where you might say, well, I think this needs to be valued by an expert.
I'm going to deal with the next question because it's one of my pet topics is AI.
Mm.
Yes, and again, I'm praying in aid of my employment tribunal experience. I am very often seeing AI generated pleadings and so on, and how to deal with them. The question was the schedules of loss generated by AI, which are very lengthy and hard to see accurate reasoning. Any tips for dealing with these? I think deal with them in the way you would any other schedule of loss or any other pleadings. They are an element of pleadings. So if in your view they are incomprehensible and you can't make head or tails of them, you can't really reasonably respond to them, then I don't see why in theory the normal strikeout procedure wouldn't be available to you. You could strike out a schedule of loss for the normal reasons that it can't sensibly be responded to and require them to provide a better one. But my view is always that if you can actually make sense of it, do so. Requiring going for a strikeout application and simply getting an order that somebody puts slightly more clearly something that you already actually understood is just a waste of costs and is not likely to be sensible for anybody unless it's tactically advantageous for any reason.
Yeah, I agree. It's a bit like a sort of particulars of claim, isn't it? If they're incomprehensible, you would always start by writing back to the other side and saying, well, we need further and better particulars of this because we can't understand what you're saying. And only potentially only if they'd refused or if they'd given further and better particulars that just weren't very helpful, would you then say, well, we've tried to remedy it and we can't, particularly where it's a litigant in person, I think. And I think there is a qualitative difference between a document drafted by AI that is just incomprehensible and a document drafted by AI that has hallucinated cases in it, because that's obviously a more serious matter, as we all know. And we hope that that would be coming from a litigant in person. But if it's coming from a practitioner, then that's another kettle of fish again.
I think where there's hallucination of cases, my approach in the past has been, and this hasn't been schedule of loss specific, has been in the first instance to simply go to especially with litigants in person, to go to the other side and say, we can't find these cases. Are you sure they exist? Are you sure you don't want to withdraw this document in its entirety and start again?
Yeah.
Rather than all of the delay and cost of going to the court for a strikeout when that's what you're achieving anyway. Do we see more personal injury claims against HEIs because of quacks? Possibly, I think is the answer. Of course, you get the cost protection if there is genuinely a personal injury claim. Um, there are, of course, safeguards that mean that that shouldn't be abused. But I suppose, one point flowing from that, there's very little you can do about it if there genuinely is a personal injury element involved. Quite properly, they're protected by quacks. One thing you can do about it is to just make clear at the earliest stage of litigation whether or not it does involve personal injury.
Mm,
So at least then, from the defendant perspective, if you have it in open court or in pleadings or in open correspondence that there is no personal injury claim, it will of course be much more difficult for them, for a claimant to later seek to rely on quacks by way of an amendment or otherwise.
mm.
Do we see more as a result of quacks? It's difficult to say, isn't it? One hopes that it's not cynically abused. Might it sometimes be cynically abused? I'm sure.
And I
Um,
think you get false positives as well, where so a lot of my higher ed cases involve pre-existing disabilities, and I think in those cases there's always a slightly increased possibility of seeing a personal injury claim as well, because it's quite common for the claimant to feel very affected by whatever the unlawful conduct is that is alleged.
and then final question that we have in the box is, uh, with respect to injury to feelings for a university claim, would it not be reasonable to refer to the OIA's PTR guidance, which sets out brackets for compensations for the same?
So it's an interesting question. I think that the Vento, so you wouldn't want to refer to the brackets for compensation themselves in terms of the figures, because generally speaking, they're below 5,000 even for severe for sort of severe effects. So I think the factors to be taken into account might be quite useful if you're looking at kind of institutional failings. So on the OIA's website, they've obviously got the brackets for compensation and then the factors that you take into account in deciding where they are. So those might be quite useful to focus your mind as a practitioner on what might put you in the moderate, in the sort of the kind of less severe, moderate, and more severe categories. But I don't think I probably wouldn't overtly refer to them. I'd more use them to inform my reasoning, I think.
Yeah,
Alex?
I agree. There's just no reason. Just because OIA is specific to higher education doesn't mean that the OIA's guidance takes precedence over the Judicial College guidelines. So yes, it's probably a useful resource, as Charlotte says, to kind of calibrate your thinking. But the amounts, I use the Digital College guidelines, and the Vento bands. That's what the court will be using. So there's no reason to kind of
I
mislead
agree.
yourself by using a separate resource.
I agree. We've got one additional question, which I think from me it's a simple no, but we have had the question, have we seen any claims under the DMCC regs in the education sphere yet? And the answer from my perspective, I'm afraid, is literally just a very straightforward no. I'm not aware of having seen anything like that yet. Okay, thank you so much, everybody, for coming to see this. We have really enjoyed delivering it, and we hope that it has been useful for you.